Welcome, everyone. I'm Chris Holcomb, Branch Manager for Heritage Financial Advisors in Columbia, Maryland. I'm glad you're here. Today, we're going to talk about estate planning. Why are we talking about this now? After all, it could be argued that there's nothing new about estate planning. It's been around since the laws governing property and ownership rights were created. We take these laws for granted today, but they're very important. They protect your right to own certain property and not worry about someone else, your neighbor, or the government taking it away. When you have ownership rights, depending on the type of property, you can enjoy it for your own use, sell it, or give it away. When you die, ownership will be transferred to another individual or entity according to the laws of succession. For example, to a spouse or child, then that person has full ownership rights. The laws of succession governing the transfer of property at death are clear and specific, even though we may not always know what they are. For example, in some states, everything owned by one spouse automatically goes to another spouse. In other states, it's split between the spouse and children. So estate planning really starts with knowing what the laws are in the state where you live. Then you decide if you want to take the law into your own hands, so to speak, by drafting a will or trust to name the people you want to receive the property after you die. But estate planning involves so much more than wills and trusts. How you hold the property in the first place can have repercussions both while you're alive and after you die. And what about your IRA? Most people sign their IRA beneficiary designation forms without giving much thought to it. But these forms are powerful estate planning tools that need to be coordinated with the rest of your estate plan. The point is that the laws governing property ownership and property transfer are very complicated, and you need to know what would affect you and your family if you died tomorrow. If you want to override these laws in some way, which most people do in order to make things easier for their family, you need to get proper legal documents drawn up. This is called getting your affairs in order. Everyone needs to do this. But estate plans involves much more than wills and trust. How you hold the property in the first place can have repercussions. Again, welcome. I'm Chris Holcomb, Certified Financial Planner and Certified Kingdom Advisor, Charter Retirement Plan Specialist for Heritage Financial Advisors in Columbia, Maryland. Welcome to today's presentation. What we'll cover in today's presentation is not legal advice. Please speak with an estate planning attorney for more details. Anything can happen to anyone at any time. Even in normal times, the news is filled with stories about accidents, natural disasters, sudden illnesses, and other unexpected events that upend people's lives. You just never know. And then there's the biggest mystery of all. Actually, the fact of death is very predictable. None of us are going to make it out of here alive, but the timing is usually unpredictable. That's why we need to get our affairs in order so we'll be ready when this happens. Because the laws governing property ownership and property transfer are intangible, it's easy to ignore them. But death is a legal event. Once a person dies, these laws come into play and they determine what will happen to your assets and your possessions. That is, who the new legal owners will be. If you've done your estate planning, you can live with the rest of your life knowing that when your time comes, your loved ones will have the law on their side because you set it up that way. Because estate planning is so important, I'd like to spend a few minutes talking about what could happen if there's no estate plan. If you're unfamiliar with some of the laws that could affect you and your family, this could be your wake-up call. Let's say you got into a car accident, had a stroke, and couldn't communicate with medical personnel about your treatment options. Wouldn't you want someone to be able to make medical decisions on your behalf? That is what a healthcare proxy does. It allows you to name someone you know and who cares about you to give instructions and permissions to medical personnel, if you're unable to do so. This is often the first part of estate planning because it's the easiest to implement. Your doctor may even have the form. Put it on your to-do list and get it done. While you're thinking about the possibility of becoming incapacitated, and I promise you, once you get these documents signed, you won't have to think about it anymore. Also consider your financial and business dealings. Who would pay the bills? Who would transact business? If there's no power of attorney, no one would. This is another thing that's easy to cross off your to-do list. Sign a power of attorney appointing someone you trust to manage your finances in the event you're unable to do so. Take a moment right now and think about what would happen if you died tomorrow. Would your family know what to do first? Would they know who to call? Would they know where your important papers are? Do you have pets that need to be taken care of? Would they know what kind of funeral arrangements you might want? Death of a loved one is always a shock to the family. but you can make it easier on them by writing out a letter of instruction. This would not be a formal legal document, but it's an important part of estate planning because it expresses your wishes about miscellaneous things and may even include expressions of love and gratitude. You could even make it a video. The laws governing property ownership and property transfer are meant for your protection. After your death, there will be a freeze on your assets so other people can't come in and take them before everything is sorted out. Depending on how your accounts are titled and what other estate planning measures you have in place, this could mean that the people closest to you would not be able to access assets until the law says they can. Worst case, your surviving spouse wouldn't even be able to get money out of the bank. But let's say your money is in a joint account and your surviving spouse's immediate cash needs would be met. What about their ongoing needs? Will your surviving spouse have enough assets to carry on and live comfortably? Will those assets be positioned in a way to generate sufficient income for the rest of their life? For married couples, estate planning needs to span two lives. The laws of succession we talked about will kick in and decide who gets your property after you die. Or rather, what will happen if you don't intervene and effectively override the laws. Here's a chilling example. When singer Barry White died in 2003, he was separated but not divorced from his second wife. In the eyes of the law, he was still married. So his ex-wife got everything. His live-in girlfriend of several years and 9 children received nothing. This is why estate planning starts with a basic knowledge of the law. Who will get your property if you die tomorrow? Even if your situation isn't as dramatic as Barry White, you may want to finesse the distribution of your assets. Maybe you want some to go to grandchildren. Maybe you have a friend or non-relative that you'd like to leave money to. Maybe you have charities that you'd like to continue to support after your death. There are so many ways to design an estate plan, and they nearly all improve upon the laws of succession as they were written by your state legislators. Now that the estate plan exemption is over 12 million, 24 million for couples, people have gotten complacent about estate laws. And it's true, if you died tomorrow and all of your assets totaled less than the exemption, there would be no estate taxes. But there are two things to say about this. First, the exemption amounts are scheduled to go back down to 5 million, 10 million for couples in 2026. If you continue to procrastinate, and if Congress doesn't extend the current exemption amounts, your estate could be subject to estate taxes. The other thing is that estate taxes are not the only taxes you need to worry about. Some states impose their own estate taxes with lower exemption amounts. Some states impose inheritance taxes on their heirs. And if you will be passing on an IRA, your beneficiaries may have to pay income taxes on the distributions. These taxes usually can't be avoided, but they can be reduced or deferred if managed right. Another big part of estate planning is preparing your beneficiaries for their new responsibilities. Well, they know how and when they must take RMDs from their inherited IRA. Traditionally, estate planning was done in secret. This was partially because no family wants to talk about death. And it was also because the patriarch or matriarch didn't want to start any family squabbles. Better to let those happen after they're gone. But today's modern form of estate planning is much more transparent. People want to help their children. Adult children often know how much of an inheritance they can expect to receive, and this gives them an opportunity to prepare for it. At the very least, you can introduce your kids to your financial advisor so that they can start working together. Then when the time comes, your children will have someone to turn to and can help them with their RMD and other things. Okay, let's say you already have an estate plan in place, you've seen a lawyer and had all the necessary documents drawn up. It feels good, doesn't it? I can tell you from experience that my clients who have done their estate plans feel like a weight has been lifted from their shoulders. They know their affairs are in order and their wishes can be carried out after they're gone. If this is you, congratulations. I have to tell you that the job is never completely done. As you move through life and your financial situation changes and your family composition changes, your estate plan will need updating. We talked about the sad story of Barry White, whose ex-wife inherited his estate to the exclusion of his living girlfriend and their 9 children. There's also the story of Heath Ledger, whose 2-year-old daughter was left out of his will because he never updated it after she was born. Instead, everything went to his parents and 3 sisters. This story has a happy ending, though, because Heath Ledger's family gave all the money to Ledger's daughter, but not all families are fair-minded. Also, sometimes people do their own estate plans but fail to finish the job. Michael Jackson created a revocable trust designed to transfer his wealth to his children and his mother when he passed, but he never funded the trust. Instead, his entire estate was left outside the trust. The estate had to go through probate process while Jackson's children and his mother lived off an allowance managed by the estate's executor and the judge. This went on for years. During the probate process, the estate faced numerous legal challenges from creditors as well as Jackson's family. Now let's look at some situations that may call for updating your estate plan. How much has your house appreciated in value since you did your estate plan? How about your retirement accounts? Even if you're still under a federal estate tax exemption amount, the increase in assets could call for a different strategy, different tools, and different decisions about who gets what. Or maybe you have fewer assets than you once had due to portfolio withdrawals or investment losses. Reduced assets may call for different plans. Maybe you're not feeling so generous today. Perhaps a gifting program you set up seems a bit unaffordable today. Remember, estate planning is not just about transferring assets after your death, it's also about ensuring lifetime income for yourself and your spouse. If your assets have fallen in value, you may want to revisit your estate plan. Children grow up. That minor child you provided for in your will may now be well past the age of majority. Those young adults who once couldn't handle a large pool of assets may be all grown up and perfectly capable of handling an inheritance. Or maybe your adult children are in a place where they could use a part of their inheritance now. If they need money for a house or business, and if you can afford it, why not help them? Lifetime distributions are a part of estate planning, and you get the satisfaction of seeing the money be put to work by the people you love. Have there been wedding bells in your family since you did your estate plan? Have you welcomed a new son-in-law or daughter-in-law? This new union has legal ramifications with respect to your daughter's or son's inheritance. Even if you welcomed your new family member with open arms and are happy to share the wealth, your child's new marital status requires a fresh look at your estate plan. The birth of a child always requires an estate plan update. Even if your will or trust was written to include grandchildren not yet born, so as not to unintentionally disinherit them, you want to bring your documents up to date to name the child and to make any necessary revisions. If you've already gotten divorced or remarried and haven't updated your estate plan, we'll excuse you while you go talk to your attorney right now. This is one of the biggest estate planning blunders of all. Keeping an ex-spouse as beneficiary on a life insurance policy or retirement plan, or even a will or trust. People who have gone through a divorce are usually so tired of dealing with lawyers that they put off updating their estate plan, figuring they will take a little break and do it later. Then they never get around to it, which is tragic. Or what if you have a new spouse? This union brings its own legal consequences. If you have children from a former marriage, you want to balance everyone's needs and make sure your estate planning documents reflect that. We're not here to tell you how you should plan your estate. Some of these decisions can be difficult and complicated. We're just here to remind you that if you don't update your estate plan following certain legal events such as a divorce or remarriage, disaster could ensue. Proactivity is what we like. If you haven't made a move but are thinking about divorcing your current spouse or remarrying a new spouse, please put your estate plan front and center. Remember, until you actually divorce, you're considered married in the eyes of the law. Because it may be difficult or impossible to remove a soon-to-be ex from certain accounts while you're going through a divorce, and because certain estate planning changes can complicate the divorce proceedings, you need to consult with both your divorce attorney and your estate planning attorney. Tax laws have changed. Yes, they have. Tax laws may have changed several times since your estate plan was done, and unless you are a lawyer, you may not have known which laws might affect your estate plan. Most good lawyers stay in touch with their clients and notify them when their estate plan needs to be reviewed in light of new law changes. But maybe the lawyer who did your estate plan hasn't kept in touch, or maybe they did, but you ignored their communications. It's very hard for ordinary people to keep up with tax law changes. For one, when you're getting information from the news, it can be confusing over which laws have been passed and which laws have been proposed. Among the laws that have been passed, it's sometimes not clear when the effective dates are, and some laws are so complex and arcane, it's impossible for an ordinary person to understand their effect. For example, the laws governing all the different types of trusts are nearly impossible to understand without a deep understanding of how those trusts work in the first place. One of those trusts could be perfect for your circumstances, but you'd never know it without an estate plan review. I'll just say this: it's been more than a couple of years since your estate plan was reviewed. It's probably time. Tax laws are going to change. Yes, they will. As politicians come and go, we can count on new legislation every so often to undo the last round of changes. Also, because many of our laws are due to sunset at a specific time, we know the laws will change. We don't know if Congress will allow the laws to sunset, which means they'll go back to the old way they were, or if they'll pass different legislation before the sunset occurs. All we know is the laws will be different in the future. Estate planning lawyers have their work cut out for them trying to draft documents to accommodate changing laws when they don't know what the new laws will be. But frequent reviews and revisions can help you stay on top of things. And remember, what matters is what laws are in effect when you die, not at the time you draft your documents. Many of the laws governing state planning are state laws. Now, some estate planning documents can carry over from state to state, but some need to be drafted anew to comply with this new state's requirements. And there might be some different laws in the new state that change your strategy. Bottom line, if you move to a different state since you had your estate plan done, make an appointment with an attorney in your new home state for a thorough review of your plan. You won't be around to watch, but your executor, successor, trustee will be very busy after you die, rounding up your assets, accounting for everything, and eventually distributing them to the beneficiaries you've chosen. But while you're alive, you may want to keep tabs on this person. Presumably, you've chosen someone close to you and whom you trust implicitly. It could be an adult child, a family friend, or a trusted professional, preferably someone younger than you. You may also have named a successor, executor, or trustee to step in if the first person isn't available. Keep tabs on these people. If you discover that the person or people you named are not able to do the work of administrating your will or trust, you need to name someone else. This happens. In fact, one of the reasons people put off doing their estate planning is they can't exactly decide whom they want to inherit their assets. It's okay. These can be hard decisions. But it's better to take a stab at it than not have an estate plan at all. Your will or trust can always be revised if you change your mind. If you've forgotten who you named as beneficiaries, it's definitely time to update your plan. Pull out your documents and read what's there. Is this still what you want? Have you changed your mind about anything, especially in light of some of the things we've talked about, like a new family member or a change in marital status? If so, it's time to update your plan. Preparedness is the antidote to fear. This is a famous quote that applies to so many areas of life. Some people fear death because they worry about what will become of their loved ones after they're gone. Your family will miss you, of course, but with a solid estate plan in place, at least they won't have to wonder what you would have wanted and can help you make sure your wishes will be carried out. Your estate plan may be all about stating your wishes, but really, you are doing it for them. Take the time and the trouble to get your affairs in order is one of the most loving things you can do while you're on this earth. I hope this presentation has opened your eyes to some of the issues surrounding estate planning. What I'd like to do now is make an appointment to sit down with each of you and help you determine what you need. We have a estate planning assessment that's pretty simple and quick. Once you determine what you need, we can make a plan for checking off the items that need to be done, whether it's organizing records or meeting with an estate plan attorney. Whether you're doing an estate plan for the first time or have questions about your existing plan, we'd love to help. Thank you for taking the time to review this important topic with me. Please reach out to us if you have any questions or if you want to schedule time to talk. We hope to connect with you soon.